All right. Well, I know Mr. Crawford knows about it because he emailed his departure motion this morning.
Yes, Your Honor. I just seen him, so he said he was heading down to get on the Zoom
Okay.
call.
All right. He might just be a little delayed here. Mhm. Not yet. How long ago did he leave you there, Mr. Radford?
About 15 minutes ago.
Okay. It sometimes takes a while to get out of that jail. They gotta bring the elevator for you and all that stuff. So we'll be patient. He'll be here in a moment.
Okay.
Hopefully he's just running up to the law library.
Up there he is. All right. Mr. Crawford, I got your motion for directional departure. I have also received the PSI with the LSIR attached, so I think we're ready to go. Does anybody need to talk about anything before I call the case?
No, Your Honor.
No, Your Honor.
Therefore, we will be on the record in case number 2019-CR752, captioned State of Kansas versus Richard Radford. Would the parties announce their appearances, please?
May it please the court, this state appears by Assistant District Attorney Claire Thibodeau.
May it please the court, Your Honor. Mr. Radford appears at the jail in custody with counsel Phil Crawford, who appears via Zoom from another location.
All right. So I should note before we get going here, Ms. Brown reached out to me earlier today and indicated that as I said, the 1, 2, 3 assessment has been done. Unfortunately, due to some of the things in Mr. Radford's criminal history, he's not eligible for a bed at Mirrors, or was there somewhere else, Ashley, that you mentioned?
There's just the locations in Mir for Kansas City, Kansas, and Shawnee, Kansas, and Topeka. He is not eligible for those.
Okay.
But
so I don't know if she passed this on to you all today, but it's going to be Miss Brown's request that Mr. Radford stay where he is while she arranges a inpatient bed in a facility that will accept him, and that he be transferred directly from the jail to that bed by community corrections. So I just wanted you all to know that before I start asking for comments about what I should do today, and make sure that we're all on the same page. All right. So we are here for a sentencing today. The record should reflect that the parties were last in court also by Zoom back on November 20th of last year. At that time, the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, and set it for sentencing today. I've received that PSI, including the required Senate Bill 123 assessment. The critical findings are as follows. The sole count of conviction is one of possession of morphine. That is a severity level 5 non-person drug felony. The defendant's criminal history score was found to be that of D, as in David. That would leave him with a border box presumption with a standard range of 24 months, a mitigated of 23, and an aggravated of 26. Special rule number 9 applies, that being a crime committed while on parole. If he has to do that time, he's eligible for up to 20% good time credit, and subject to post-release supervision duration of 12 months. If he's granted probation today, it would be to community corrections for a period of 18 months. As I noted earlier, Senate Bill 123 does apply and the required assessments have been done. So I would ask you first, Ms. Kebido, have you had a chance to review the PSI, any additions, corrections, or challenges to those findings?
Your Honor, I have received a copy of the PSI and I have reviewed it. I don't have any additions or corrections.
Mr. Crawford, same question.
I have received the PSI. I got it yesterday. I was able to get up to the jail this morning and discuss it with Mr. Radford. We went over the criminal history as outlined in the PSI. There are no objections or challenges.
All right, thank you. Mr. Crawford, as I stated earlier, I have received and reviewed your motion for durational departure. Do you wish to be heard on that this morning?
I could be heard on it briefly.
You may.
Hello?
You may.
I don't want to just clear up a couple things, or at least one thing. I did not have an opportunity until this morning to go by and get him to waive his physical presence for the sentencing hearing. He has signed the form. I will email, or I will scan and send the form to you after the hearing today, but it has been done.
Excellent. Thank you. All right.
I'm sorry, I lost you there for a minute.
I said, I appreciate that. And if you're ready to make comments on your motion, I'll hear them.
There's case law out there that's been out there since the mid-90s with regard to the ability to reflect on how elapsed priors are and whether that is in fact a substantial and compelling for a departure. I've outlined that in the motion. I believe in this case, we've got about a 10 or 11 year period. So the court could consider that and elapsed enough time to drop the number down from where it is mid-box 24 down to 12. We had good faith negotiations in this case, Mr. Campbell and I, with regard to coming to an agreement that we would jointly recommend a 12-month sentence with the knowledge that he had Mr. Radford had a parole hold and he's going to have to take care of that. Court set this out long enough for that parole hold to try and get something done with it, but unfortunately nothing happened. They didn't pick him up, so he has been sitting. He's been sitting in custody since December 9th of 2019. So clearly, if the court grants this motion, it would be with the idea that he's basically time served. I understand the probation process, and they're wanting to do this through Senate bill to decide whether he needs treatment. But I'd ask the court to consider the good faith efforts that were made in negotiating this matter down to a 12-month sentence. He's waived prelim. There's no cost associated with bringing in witnesses, so he's made this easier cost-wise with regard to the court system. I'd also ask you to consider that. Mr. Campbell and I took significant time getting this done. I was the second attorney on this matter. There was some significant negotiation that led to us jointly recommending a 12-month sentence. And I'd ask you to find today that there are substantial and compelling reasons for a departure down to 12 months.
All right. Ms. Thibodeau, your position on defendant's motion.
Your Honor, I've reviewed the defendant's motion and I have no objections. For jail credit, I have that the defendant has been in custody since December 2nd of 2019 until today, which would be 424 days. So I would jointly recommend the 12-month prison sentence for the defendant and for him to have time served and go on his post release. I would also say that special rule number 9 applies. So I'd ask your honor to order this case to run consecutively to 2010 CR 176, which is a Wyandotte County case.
Right. All right. Well, look, my intent is to completely follow the plea agreement on this, and I'm going to finish up with this. My question is this: if he's been on a parole hold this entire time, and I run this case consecutively to 2010, when DOC calculates his time, are they going to give him credit for all this time that he's been in? I want to make it clear I want him to. I'm just not sure that DOC is not going to say, well, he was sitting there on a parole hold the whole time, Or maybe they give him 90 days as the sanction on parole and charge that versus his parole and everything else to this sentence. I don't know what that's going to look like, but I think the parties need to think about that, because if they, because of the parole hold, they charge all that time to his old case, he's not going to have that credit for the time you've talked about.
Well, Judge, he has served more than a year, so if parole does some of the days for them and then the 365 for ours, then he would have completed our sentence already.
All right. So I guess Ms. Thibodeau and Mr. Crawford, here's what I need to know. I was under the impression that the parties were wanting me to impose a sentence and then grant probation. Are you asking me just to assume that whatever he's credited on in this case flattens out his sentence there and just send him on to post-release? I'm not against that. I just want to make sure that that's what the parties were contemplating.
Yes, Your Honor, that's my understanding, is that Mr. Crawford is not asking you to make the border box findings.
All right. Is that correct, Mr. Crawford?
The understanding that I had when we negotiated this matter with Mr. Campbell, and I believe Mr. Radford would agree that that was what we were contemplating. It would appear if he gets credit simply for 365 days, he still has 69 days outlying that he would get credit for on parole.
All right. And Ms. Brown, this kind of negates the Senate Bill 123, right? If he's not granted probation, then post-release supervision just decides what kind of treatment he has to get and things like that. Am I correct in that?
That would be my understanding. Yeah, Senate Bill 123 would be if he would to get probation on this case. So if that doesn't happen, then parole, yeah, would have to set him up with treatment.
Okay. All right. Okay, Mr. Radford, before I pass sentence today, now is your opportunity to tell me anything I need to know in mitigation of your sentence.
Yes, Your Honor. I've been incarcerated since December 2nd in this county, but I've been incarcerated for almost 2 years now. February 5th to be 2 years. I was in Johnson County for 9 months too. So, but yeah, I didn't understand what you guys were saying about so I won't be getting probation, correct?
The party's belief is you either have finished this sentence by sitting there or are really, really close to have done so. So they're not requesting that you be ordered on to probation, that basically DOC calculates your time, and if you're done, you just go straight on to post-release.
Okay, yeah, and before this happened, I didn't get any time credited until after I had got there to see the parole board. So I don't know how that works, or if there's a recommendation that maybe I could get some of the time served or what. But last time they said, yeah, it didn't count. And then I said they sentenced me out to 5 months on a violation.
All right. Well, recommendations don't help because they have policies and they do the math and they figure out what you get or not. Here's what I'm going to do. I'm going to assume today that the parties are right, and I'm going to follow this plea agreement. I'm not going to give you probation. So hopefully you flattened your sentence out and you just go on to post-release. If we get surprised when you go see the parole board and they say, no, we're going to charge all this time to your old case, and you now, since the judge didn't give you probation, then you're going to have to go do this time too. Then you need to let Mr. Crawford know that that's happened, and I will entertain a motion to reconsider, and we'll redo this thing so it doesn't do that to you. Okay?
Okay. And then with the treatment, I just asked them for the treatment. That's how that works, because I was actually looking forward to that. So
right,
I can go through
if you're not put on probation, when you're put on post-release, it's just like the old parole that you were under.
Okay.
You'll have an officer and you tell them what you're telling us. Man, I want inpatient treatment. I need it. I want to be clean, and they'll get it arranged for you. Okay.
Okay, yeah, that's great. I just want the right tools, for whenever I get out. So I'm prepared this time.
Okay. Ms.
Okay.
Thibodeau, Mr. Crawford, is that satisfactory to you? If we find out that we're dead wrong and we've made him serve extra time, Mr. Crawford can just motion up to come back and we'll try it again. I think Claire might have frozen.
Oh, sorry, Judge, I have never done that before, but if Mr. Crawford thinks that that would correct it.
I haven't either, but I look, if we did that and for some reason we ran afoul of what we were supposed to do, it would take one of the parties appealing the decision to do that to really affect it. So, well, I hope it's clear that the long and the short of what I'm trying to do here is honor the parties' agreement as to getting him on his way, since he's been sitting in our jail for a year and a half now. And if we did it wrong, I don't want to say, sorry, I've sentenced you, I've lost jurisdiction, you're done. I just need a motion to reconsider, and we'll come back and try and execute the parties' agreement.
Well, I think as long as the journal entry only gives credit on this case for the 12 months, I don't know why they can't, DOC can't see that and do it correctly.
Yeah.
And I can call sentence computation up at DOC and give them a heads up.
I'm comfortable doing it today, and I think it's going to work out. I'm just afraid that, like I said, that we think we're doing this so that he can get out today. And if for some reason it pops up and they don't credit him like we think they will, that he ends up doing another year. So if anything goes wrong, Phil, just let us know. We'll fix it.
Okay.
All right. Any legal reason why I should not now proceed to sentencing?
No, sir.
All right. I am going to follow the agreement. I'm going to grant the motion for downward durational departure. I'm going to adopt as substantial and compelling reasons those set out in the defendant's motion and defense counsel's comments today, specifically the age of the prior offenses and the defendant accepting responsibility, saving the state the time and expense of preliminary hearing and jury trial. In the court's opinion, those are both substantial and compelling reasons to depart from the sentencing guidelines. Therefore, the defendant will be sentenced to a period of 12 months in the Department of Corrections. He's eligible for 20% good time credit on that sentence. He is not applying for probation under the border box today, and therefore probation will not be granted. He shall be granted jail time credit for all of the time chargeable to this case. Let's see. When it comes to costs and fees, let me take a look. I'm kind of a mind, since I'm not granting probation today, and Mr. Radford has been sitting in jail this entire time. Ms. Thibodeau, I'm thinking about waiving costs and fees here. He's already in the database, so he doesn't have to pay the DNA fee. The drugs weren't tested, so he doesn't have to pay the testing fee, which would leave him, if I do waive court costs and attorney fees, with nothing to pay. Your position on that?
I defer to the court, Your Honor. I'll note that on the journal entry.
All right. I think he's kind of gotten more of a sentence given his circumstances than he would have otherwise. So here's the way I'm doing this. I'm waiving the court costs. There is no supervision fee because he's not being granted probation. I'm waiving attorney fees. He's already in the KBI database. There is a minimum fine listed of $400, but that's under Senate Bill 123. And if he's not granted probation, he's not to be assessed that fine. Am I correct in that, Ms. Brown?
Yes, I believe so. The fine only applies if he's on that probation.
Yeah, okay. So that would leave him with nothing to pay. And I think that's serves the ends of justice in this case. All right. Let's see. Other things that I have failed to cover today, Ms. Kevido, I guess I should advise the defendant, you have 14 days from today to appeal anything you don't like about your sentence. You may be able to seek expungement of this after a period of time following successful completion of post-release supervision duration. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. All right, with that, Ms. Kebido, anything I've not covered today?
I just want to clarify with you and Mr. Crawford that you would only like me to write 365 days on this journal entry? Or
For
should I
jail
write-
time, for jail time credit?
Because I have 424, but if Mr. Crawford thinks we should just grant the 12 months, I just want to clarify.
I think that is is probably the best way to make sure that because if he gets the 365, then he's flattened out this sentence. And then if there's a question about it, all those other days could be charged to any kind of parole sanction. So yes, 365 days on this case, and the rest can be calculated by DOC if there's anything left on that old case. Okay. This has been a little bit of a strange duck today. I guess my next question is, would I be issuing an order of commitment? And maybe Mr. Jones can help us out on that. Do I issue an order of commitment and then they do the calculation and let him go because he's done that? Or do I issue a release today?
It's a commitment, Judge.
A commitment for the
Yes.
time? Okay.
Also, Judge, in the affidavit, it says that the drugs were sent to the KBI laboratory for testing.
Ms. Kebido, that's would be unusual. Do you know if that was in fact the case?
If it's in the affidavit, I believe it would be, Judge, but I also believe that you have the discretion to waive whatever costs and fees you.
Okay,
I know other
I would-
judges have done that.
right. On the lab fees even?
I've had other judges say all costs and fees waived.
Okay, I'll do that. I don't know what if it's, and I'm sure I'll get a letter from KBI if they feel that I don't have the authority to do that. All right. Other things that we need on our record today?
I don't know of any.
No, Your Honor.
All right, then we are adjourned. Good luck to you, Mr. Radford. I'm going to be sending over a commitment, but my guess is they're going to do a bunch of calculation. You're going to be, do you have any other holds? Do you know?
No, just a misdemeanor warrant that I can get paid.
Where is it out of?
It's here, child support and
Okay.
KCK.
All right. So that should be easy enough to do, and maybe that'll give them time to calculate your time. All right.
Okay.
Well, good luck to you.
Thank you so much, Your Honor.
Thank you all. Have a good day. Thank you, Rose.
Thank you, Judge.